My ex-husband Rob's behaviour was controlling, and there was the threat of violence with a weapon. He said that he would never have gone through with the actual violence, but he would raise items. It was a carjack to hit me with quite controlling behaviour to get me to do what he wants. So when we tried to discuss child arrangements, the mediator said, "You need to be clearer about what you want." But I didn't know how to say what I wanted. I did feel very alone in mediation. You've got your ex looking at you all the time when you speak, intimidating you, just glaring at you.
At the Miam, I said I didn't want my ex Dave in the same room because I felt very threatened by him. I asked for separate rooms. And then, the day before we went, Dave said he was going to get me. He was going to have me in there. I told my solicitor this. When I got to mediation, Dave was there first. He persuaded the woman to let us go in together. She said, "Are you agreed with this?" I said yes, because I was so scared. In mediation, he told me, "You can't stay in the house. You don't have any money. You agreed to leave." I agreed to leave because I was scared of him. So I said yes to everything because I was so scared. I got to go home and be with this man, so I was too scared to say anything else.
So I had counselling because of the domestic violence. I believe Gillian, my ex, had postnatal depression, and she wouldn't get help. And I had serious attacks from her. You know, I told the solicitor everything, like when she tried to drown me in the bath. I told the mediator all about the domestic violence, and it was just like it wasn't registered.
The thing is, if someone is bullying you but isn't hitting you, it doesn't count as abuse. I feel my husband, Roger, was abusive, especially given my clearly mentally ill status at that time. I told my solicitor and the mediator, but it just didn't count for anything. He's not seen as an abuser. In the mediation, he insulted me. He said that I was an inadequate mother, that my children didn't love me and wouldn't miss me, various incredibly brutal things. It propelled me into a sort of breakdown. It was one of the worst days of my life.
My ex-husband Joe is very volatile emotionally and very physically abusive to me. He even beat up our adult daughter. The solicitor asked about abuse, and I told him what had happened, but the solicitor said that I would have to go to mediation before going to court. He said, in this city, they won't take a case to court until you've been to mediation. The mediator didn't ask me if there'd been any abuse, and that's what was worrying me when we went to mediation. So I asked to be put in a separate waiting room from my ex.
Mediation was just another arena to be bullied in.
I am Professor Anne Barlow from the University of Exeter Law School, and I led the mapping project which looked at which out-of-court family dispute resolution processes, so mediation, collaborative law and solicitor negotiations, might best suit different parties or cases. Following a nationally representative survey where more than 1 in 6 who rejected family mediation did so because of fear of a partner, we interviewed 95 individuals, both legally aided and privately funded, who had used one or more of these processes since 1996, including 56 who had experienced mediation, the earliest in 2002. We also interviewed 40 solicitors and mediators. We found that the practitioners interviewed took screening seriously. Yet, in 18% of cases, on the party's account, effective screening was sidestepped. In further cases, solicitors had recommended mediation, judges had referred parties to mediation, or mediators had accepted cases where there had been violence. Many of these cases would have been exempt from MIAM attendance and should not have been referred to mediation. Some, like Gloria, were wrongly advised that mediation is required before making a court application, when only MIAM attendance, when it is safe to do so, is required. As you know, the MIAM is the statutory part of the wider information and assessment meeting held between a mediator and a potential participant prior to mediation. The purpose of this assessment meeting is to explain the mediation process and assess whether mediation is appropriate for the participants. In this video, we refer to the assessment meeting prior to mediation as the MIAM. The legal aid changes introduced in 2014 have put added pressure on practitioners to accept borderline violent and coercive control cases, fearing that self-representation at court might be worse for such vulnerable individuals. We hope that this resource will help practitioners, whether newly qualified or experienced, to ensure consistent and appropriate screening for domestic violence, abuse and coercive control in every case. Safe assistance for mediators and their clients, effective triage in all cases, and supported alternatives when mediation is inappropriate are clear goals for family mediation to ensure it is viewed as a successful and trusted process. Given the prevalence of domestic violence and abuse as illustrated on this table, we cannot underscore forcefully enough the need for consistently good screening. Post-LASPO, many clients will contact your service direct rather than being referred by a solicitor, so it is important that frontline admin staff at mediation services understand the MIAM exemptions set out in FPR Practice Direction 3A and in the C100. Prospective clients who disclose abuse pre-MIAM should, where appropriate, be referred to a specialist family lawyer and signposted to relevant support services. Details of solicitors who undertake legally aided family cases are on the Law Society's website. The Law Society, resolution and support agencies' details follow at the end of this video. In mapping, several interviewees disclosed having had a joint MIAM only. As you know, this is the key point for assessing suitability of cases for mediation. As a result of the mapping paths to family justice recommendations, the FMC Code of Practice was changed to require the mediator to see each party individually during at least part of the MIAM to facilitate proper screening. Here, the mediator and client should agree individual signs to give to the mediator to request a break if a client is feeling uncomfortable in mediation. Ideally, the legal aid eligibility assessment should not take place during the MIAM. Either train your admin staff to conduct this, or the mediator should deal with this assessment separately. This ensures that the MIAM focuses on setting the right environment, building rapport, and asking key questions to ensure the appropriate dispute resolution process is identified. It takes on average 34 opportunities with a professional or trusted individual before a victim of abuse discloses it. You must therefore create a supportive environment that enables clients to disclose their concerns to you. Face-to-face individual screening is essential in every case. We recommend that the screening assessment is based on objective judgments derived from established risk assessment tools. One interviewee, Wendy, reflected that it was only once she had received legal advice and completed the Women's Aid Freedom Programme that she realised the extent of the emotional abuse she had suffered. This is a common phenomenon. You must be prepared to decline to mediate if you assess the process to be unsafe or the parties to be unsuited to mediation. Some cases will need court adjudication, and these individuals should be referred to a specialist lawyer, Women's Aid or Men's Advice Line as appropriate. There is also a subjective element to screening. You should ask, what is the impact of the behaviour? How does that person feel? You should engage the client in a hypothetical conversation. If we mediate and I manage the process, would you feel oppressed? And would your behaviour be manipulated by the relationship's history? Mediation should only take place if the answers to these questions are no. If there are manageable safety issues, provided the client can advocate for their own interests, then separate waiting rooms, staggered arrival and departure times, shuttle mediation and co-mediation are options to consider to manage the risk. Support staff should also be on the premises as a precaution. If the client cannot advocate for their own interests, mediation is unsuitable. We return now to Tilda, whose husband had threatened her with a carjack.
Seeing the mediator alone at the MIAM was never discussed or offered, so we saw the mediator together. I didn't mention the abuse to the mediator particularly, and I didn't go into the history because it sort of never was a question that came up. But I think that my husband's attitude in the MIAM session probably made it quite clear that he was going to be quite difficult. So after the first session, subsequent mediation sessions were with 2 mediators. I think the mediators had more control when there were 2 of them.
Failing to provide Tilda with a safe space in a separate MIAM to disclose the threats led to an incorrect presumption that the imbalance between the couple could be addressed by co-mediation. Screening is an ongoing process. Both clients should have individual time with the mediator before each session to disclose concerns that have arisen since the last session. For some, co-mediating with a balance of genders where possible may be sufficient to balance power, although this was not the case for Tilda. Staggered arrival and departure times, separate waiting areas, and facilities to offer shuttle mediation should be available as needed.
Before the mediation sessions, we sat in the same waiting room, and afterwards. It was horrible. In the mediation, I just found it difficult to put my point across, and I suppose I don't know that I would have had that experience had I not been in the room with him. Having everybody together in a room as a process is really helpful, but I did feel very alone. You've got your ex glaring at you. Separate rooms wasn't something that I had thought of as an option, but I think I might have found it helpful.
We now hear Kim's story. Kim had not been subjected to the same level of threats as Tilda, but described her ex-partner Alistair as a bully.
When Alistair kept the children and things were very heated between us, I was a bit worried about being in the room with him in mediation. I spoke to the mediators about it, and they explained that we could be mediated separately, and that they would organise it so we arrived separately and left separately. That wasn't needed in the end, but the fact that all those things could be put in place, I think it means that no one should ever feel uncomfortable. I didn't know that before mediation. If I found someone quite threatening, to be in a room with them would be quite a scary prospect. But to realise that if there is any issue, you can leave that room and they'll set it up for you. You don't have to have contact outside that room. Because obviously you worry about leaving the building and that person waiting for you. So the fact that these things can all be organised and the mediator is aware of them, and at the slightest mention they're able to advise you on all those things, so they're obviously familiar with such issues.
Knowing that safety measures were available gave Kim confidence to proceed with mediation. Where, like Kim, a party has concerns about being in the same room as their former partner but can advocate for their own needs, then mediation may be suitable. In mapping, mediating cases which should have been screened out because of domestic violence and abuse, coercive control, or mental health issues led to unjust settlements. Tilda agreed to split the family assets and the cost of mediation equally, even though she was legally aided. Monica, the primary carer of the children prior to separation, agreed 50-50 shared care with her husband. Financial issues were unresolved 2 years later, and the husband remained in the substantial matrimonial home, with Monica in smaller rented accommodation. Sarah was the children's primary carer, but agreed to vacate the matrimonial home because she was too scared to object. These women needed robust legal advice and support, and potentially court adjudication, given the power imbalances. Given their traumatic experiences of mediation, we conclude with the views of Tilda, Monica and Sarah, on when mediation is or is not suitable?
I think if you have got two reasonable people, two people that are equal, I think mediation would work. But I think where you have got a really strong and dominant person, I think you need one-to-ones with a mediator who has got the expertise to try and understand the person who perceives themselves to be not as confident in representing their own issues.
Mediation was a very unsupported environment for me. The mediator obviously had to be studiously neutral, but in my circumstances, it wasn't a balanced situation. I was mentally ill. I was poorer. I was the one who had to give up my house and my job, yet it was treated as if there were no power imbalances between us, as if we were both on equal footing. And we weren't.
I think any woman who's coming from an abusive background should never be asked if it's okay to be put in the same room with her ex-partner. When mediators come across these type of men, they are very charming and polite. But you should just never be put in that situation.